Okay, good morning. I think we're ready to get started. For those of you who don't know me, my name is Jeffrey Verdon. I'm a tax, trust, and estates lawyer, and my practice is in Southern California in a small town called Irvine, although I did grow up here in the state of Florida in Miami. This year marks the 21st year that I'll be speaking at the money shows and also on the investment cruises. And if you haven't done any of the inter-show investment cruises, I really encourage you to do it. It's a wonderful way to meet the speakers, learn good information, and have a wonderful trip on the Crystal Cruise Lines. Our law firm specializes, we're what you would describe as a boutique tax firm. We specialize in doing estate planning for the larger estate owner. We have income tax strategies for those of you that have investment income that you're paying tax on, which can convert that investment income into tax-free income using a technique I'll show you this morning, right out of the tax code. And then we have a very large national practice in the area of asset protection planning for people who want to protect their assets from a financially ruinous lawsuit. And with over 100 million lawsuits being filed in this country every year, it doesn't take that much for some innocent person to be suddenly involved in a litigation. Now, this workshop is geared for estates in the under $15 million range. Some of the techniques I talked about yesterday in my workshop, I'll talk about again today. Some of the ones I talked about I did not include in the slides because they don't pertain. And if you saw my workshop yesterday, this might be a good refresher for some of the topics I quickly went through yesterday. But the best way to approach dealing with the subject matter, because I have a lot to cover and I don't have a lot of time, is to take some notes, go back, talk to your lawyers if there's something that you see that interests you. And if your lawyers don't do this sort of work, and generally if they did, you'd already have it, then certainly give us a call. We'd be happy to talk with you. You know, for me, this is a 45-minute job interview. I mean, we have met many people over the years here at the conference. We've done work for the people at the conference. And even if you have an existing lawyer, we're all too happy to work with your existing lawyer to help put some of these strategies together. Because unless you live in a large city, if you come from a small city or town, it's probably most likely your attorney is more of a generalist than a specialist, and so he probably or she may not necessarily have enough clients to do these sorts of strategies for, and therefore it doesn't make sense for her or him to specialize. So let's get into the agenda. I want to talk about some principles of estate planning that I think are important, that in my 30 years of practice I've discovered and I think would be very relevant to perhaps your approach. We'll talk about the 5 must-have strategies this morning, how we can work together if any of you are so inclined, and then time permitting, I'll take your questions. And if I don't get to your questions, I'll either be outside after the workshop or come down to my booth 801 where I'll be there until the conference closes at 2 p.m. My most important principle of estate planning, ladies and gentlemen, is never sacrifice lifestyle for tax planning. And what do I mean? I see people all the time who come to me. They're spending a lot of money for life insurance premiums. They're making gifts to their kids. They're feeling terribly constricted to attempt to save taxes, and they're not being able to live their life the way they want to live their life. And I think that's a huge mistake. This is the time to be selfish. This is the time to spend your money on yourselves, and if there's anything left over, then leave it to the kids. My best advice to my clients is spend your kids' inheritance. And if you can't do that because you have too much money, then do some tax planning. Get the kids, the adult kids, involved in the estate planning process early. It's a cathartic experience for the parents. It's a cathartic experience for the kids. They're going to be the stewards of your estate and your wealth anyway. Why not get them in the process early rather than waiting? A lot of you might feel that you don't want your adult children to know that you have a lot of money. Trust me, they already know. So you might as well just own up to it, get them involved in the estate planning, bring them to conferences like this, take them on the investment cruises, get them inculcated into the process, folks, because it's not an easy process. And if you want to make sure they're going to carry on in the fashion that you want them to carry on, then you got to get them involved. Don't start any tax planning without a roadmap. What do I mean? Well, I've been meeting with people at these conferences, for many, many years. And whether I'm talking to somebody with a $2 million estate or a $200 million estate, When I ask the question, has your lawyer put together a roadmap, a planning memo, a direction, a purpose for the reason you have all these instruments, very few people answer in the affirmative. When we sit down with a client, before we start the implementation process, I want you to understand completely what it is you're about to embark upon, because if it's not what you want, it's too late to change things oftentimes, or too expensive to change things later on. So always have a plan that you can refer back to so you can even remember why it is that you have all these different instruments. Never underestimate the role of life insurance in your estate planning. Life insurance, every major wealthy family that I've ever done planning for always had life insurance, and lots of it if they can qualify for it. Now, life insurance is expensive, but there are some new techniques out there today, one of which is premium finance, that will allow people who need large amounts of life insurance, or even modest amounts of life insurance, to buy what they need and not have to pay the premiums for it. Borrow the money, the bank gets paid back after you pass away, and we'll talk about that. And finally, folks, fly first class so your kids will. I promise you they will. So enjoy yourselves. Don't hoard your wealth for the purpose of passing it on to your children. Enjoy it. It's for you. Your kids will do fine. Okay, these are the strategies I want to cover this morning. The Offshore Asset Protection Trust, the way to convert your taxable portfolio income into tax-free income, and these other strategies we'll get to. Now, asset protection planning is number one on my list because I think it's the most important of the strategies that I can offer you. I have been an asset protection lawyer for 22 years, and I can tell you I've seen all the train wrecks. You know, you wouldn't have a house without carrying fire insurance. You wouldn't have a car without carrying car insurance. But all of you go around without asset protection planning. When I sit down with a client to plan their estates, the first thing we want to lock down is protecting their wealth against a lawsuit, because I want to make sure you have an estate to retire on and an estate to pass on to your kids. Even if you do no estate planning, Uncle Sam's going to let you keep at least 50% of your wealth. But if you get sued, your wealth can be taken entirely away from you. And trust me, the plaintiff's lawyers will have no compunction about doing so. So you may have an umbrella policy, but let me tell you about insurance companies. They might cover you if you fall off the roof, but not if you hit the ground. Umbrella policies are a year-by-year contract. If they start sustaining losses in a particular area, they shut it down. They won't give it to you anymore. So just because you carry an umbrella policy and it's good for 1 year, that doesn't mean they're going to renew that for you. And it may not be enough coverage to cover the liability suits. Whoops. So let's talk about asset protection. You all should have received a lawsuit exposure test. Take that test. If you score on the rather high end of the answer key, you need to be talking to an asset protection lawyer. The problem that many of you are going to encounter, though, is when you sit down with your estate planning lawyer, in law school they teach you about estate planning. Estate planning is the process of dealing with the disposition of your estate after you die. I never was taught anything about asset protection planning in law school, and I don't think any law schools teach asset protection planning these days. So how do you find somebody who does asset protection planning? Well, you come to conferences like this. I'm an asset protection lawyer. There's another attorney here at the conference who's an asset protection lawyer. You go on the internet, and you'll find them. If you come from a small city or town, again, you may have a challenge doing that. And again, if you don't have somebody in your community, I'd love to talk to you about it, but definitely want to find somebody if you score on the high end of the answer key. The two questions we ask our clients when they come into our office, among other things, regarding asset protection: are you confident you'll never be sued? Well, you'd be surprised. I think most people get it, that they're exposed, but this is the more important question. If you are sued, are you confident you'll be treated fairly by the legal system? And that's where it's amorphous. That's where we don't know. If you've ever experienced a jury, juries have their biases. My definition of a jury is 12 underemployed or unemployed people who couldn't get off of jury duty. And these are the people that are going to be passing financial punishment on you. So if you want to stay out of the courtroom, you have to do something to lower the prospect of getting sued, which is remove the economics from the lawsuit. Now, there are two approaches to asset protection planning. There's domestic asset protection planning, and there's offshore asset protection planning. When I first started doing asset protection planning in the mid-'80s, I was doing domestic asset protection planning. And then we had something very curious happen to one of our clients. Client was sued, had an asset protection structure in place. The law said specifically the creditor was not allowed to go into the partnership and take the partnership assets. The creditor tried, failed. The creditor went back to the judge and whined that he couldn't get the assets in the partnership, and the judge amended the judgment to name the partnership. That's like the functional equivalent of me suing this gentleman over here. I can't get his money, so I go back to the judge, and he puts this man's name on the judgment. No due process, no opportunity to be heard. Judges do things for oftentimes expediency purposes. When I learned that, what it taught me as a lawyer was I cannot depend upon the legal system. We have vagaries within our legal system, and when I give advice to clients, I'd like to be pretty certain that the advice I give the clients is what they can rely upon. So I looked to the offshore arena for more certainty. And what I found was that there are jurisdictions around the world, countries around the world, that have very strong legislation, very strong laws, and the courts uphold those laws. They don't have the nonsense that goes on in this country. They don't have contingency fee lawsuits. You remove the contingency fee aspect of litigation in this country, you remove the lawsuit crisis in America. We're the only civilized country in the world that allows a lawyer to have an interest, an outcome in this stake in the case. It's the most inherent conflict of interest. But without it, the poor and indigent could not get access to courts. So there is a social reason for it, but it has just gone too far out of control. So what I want to do when we do asset protection planning is make sure that we give our clients not only asset protection, but lifestyle protection. What's lifestyle protection? Lifestyle protection is the ability to enjoy the revenues from your assets, not just the assets themselves, but the revenues from those assets. And if you're in a lawsuit or you have a judgment against you, to be able to continue to enjoy those revenues. Because if you have a domestic asset protection plan only, once you're sued and once that judgment is rendered against you, you cannot touch the money in that structure. And if you can't touch the money, how do you maintain lifestyle? So what winds up happening, folks, is you wind up settling that case for a lot more money than you otherwise would have to. Now, I mention offshore, and sometimes when I mention offshore, people's eyes roll up in their heads. People think that the sun rises in New York and sets in California and the rest of the world is dark. Well, not so. Now, we only go offshore in our law firm when we can't accomplish what we want to accomplish onshore. It's a very important concept that you have to remember about offshore planning. You know, people often ask, is it legal to go offshore? Look, the IRS would not print all the forms that they have to print for people to fill out and file for their offshore activities if going offshore were illegal. Offshore is legal as long as you tell the IRS what you're doing. Let's define terms. Asset protection planning is simply changing the title on the assets that you have in such a manner as to protect those assets and the income from those assets from a lawsuit. Lifestyle protection, as I mentioned, is equally as important because that's what protects the cash flow that allows you to maintain a lifestyle. Most litigants settle tort cases. Why? One reason. If you can create doubt as to collectability, you're going to create a settlement. It's pure and simple. Litigation today is so expensive, it's all driven by economics. You can have the greatest case against somebody in the world, but if they have no assets or they have no money, you're not going to sue them, unless you're the ACLU. Okay. Now, distinguishing between domestic asset protection planning and offshore planning, the key point I want you to take from here, and I'm not trying to make you experts in this area, but there's a couple of key points I want you to remember. When you set up an offshore trust, and we choose jurisdictions that have very strong trust laws that are much stronger than they are in this country, we can have the trust, as you can see in this illustration, over here offshore. But the money that's in that trust, your savings, your stocks, your bonds, your securities, could be sitting right here in the state of Florida, wherever your hometown is, in Wachovia Bank, Bank of America, Charles Schwab, you name it. It's only when you're threatened with a lawsuit will those assets go offshore. The assets, the trust is always offshore because that's the jurisdiction that's going to, of the laws that we want to control the trust. But once those assets are 10 miles outside of New York Harbor, ladies and gentlemen, and they're sitting in a bank in Switzerland that has no U.S. branches, there's absolutely no way a U.S. court or a U.S. jury or a U.S. plaintiff can ever reach those assets. So while you're litigating this lawsuit, you're sending your bills over to the trust company, and they're paying your credit card bills, your mortgage payments, your income taxes. And so when I sit down with the opposing counsel, and I'm explaining to the opposing counsel that whatever they're doing in the States is not going to impact my client's lifestyle, do you think that opposing counsel, particularly if he's on a contingency fee, is going to want to pursue my client? Or his client who's shelling out tens of thousands of dollars a month or more in litigation bills is going to want to continue to pursue my client? No. They're going to settle. So that's the key point I want you to understand about asset protection trust, and I'll move on. Yes, sir.
You said before that a judge could, even though it may not be right, could order someone to put the money back, or can they do that in this case? If you've got an offshore trust and your money's here, can't the judge tell you, bring that money back here because I want you to give it to these people?
Good questions. The gentleman says, can't the judge order me to bring it back? Well, first of all, my trusts aren't designed so that the clients are the trustees. My clients don't have the power to bring the money back. If the judge ordered me to fly off the top of the building, if it's legally impossible for me to do it, I would do whatever the judge tells me to do, but I don't have the power to bring the money back. And therefore, you can't do something that you're not empowered to do. So if it's designed properly, these issues, the case will settle far earlier than before it gets to that particular stage. Okay, let me move into something that for those of you that have taxable investment income, and you're going to begin to see your tax rates go up, I believe, as soon as the Democrats, and I think they'll get into the White House, and so it's going to place a great deal of emphasis on being able to have a more tax-efficient way to manage your portfolio. And I've been talking about this at the money shows for years and years and years. One of the things that you want to do is to be able to eliminate the tax on your income, on your investment income. This does not apply to earned income. It only applies to investment income. And by that I mean capital gains, interest, dividends, and royalties. Now, one of the ways that you can do that is an old adage or old line asset class called life insurance. Most of you know, but you probably haven't thought about it, that a life insurance policy, the earnings inside that policy, if you have cash value life insurance, you do not pay any tax on the earnings in that policy. I used this example yesterday. If I were to give $1 million to Pacific Life to buy a variable universal life policy because I was a mutual fund investor, and I bought a policy and I made $100,000 that year in profits, Pacific Life is not going to send me a 1099, nor is the company that I invested that money with. Let's say it was Vanguard Index Funds. If I took that same $1 million and invested in the Vanguard Index Fund in my living trust or my family partnership, I'm going to get a 1099. I'm going to pay tax. Why? Because since the tax code was written, life insurance policies do not pay tax on earnings from capital gains, interest, dividends, or royalties. Now, unless you're a mutual fund buyer, then this particular structure would be of no use to you. But folks, you can even take the $100,000 in my example out of the policy through a policy loan and pay no tax on it. Now, folks, I don't know why Congress lets us get away with this. It certainly isn't fair, but it's the way it's been, and it's probably the way it's going to continue to be. And so why not take advantage of it? When I die, the money inside the policy, the death benefit, is not subject to income tax, and if I structure it properly, the assets are not includable in the estate, and it's out of my estate as far as asset protection is concerned. So it really is the penultimate tax shelter we have, and it's right in the tax code. So the IRS and Congress is quite familiar with it. Now, the one thing about these policies is that the domestic insurance carriers do not let you invest in alternative asset classes beyond mutual funds. They could, but their marketing model is a very general model, and it's very simple for the insurance companies to let you have mutual funds. But if you start investing in other assets like real estate or hedge funds, which are highly tax inefficient, or private equity funds, the insurance companies, the domestic insurance companies, don't allow you to do that. So what we've gone offshore. There's a whole industry of offshore carriers that will sell you a policy that looks just like a Pacific Life or a Mass Mutual policy. They're U.S. tax compliant, but they have the flexibility of allowing you to invest in alternative asset classes. Now, is using an offshore insurance company legal? Is it safe? Yes, it's legal, because as long as you tell the IRS you have it and you file the appropriate reports, the IRS doesn't care because it's in the tax code. So we want to use a company that has a U.S. tax-compliant contract. Your portfolio that's going to go into this policy can stay right in the same state, city, or town that you live in. If you're at Wachovia, or if you're in Charles Schwab, you can keep the same account in your insurance policy. And to make sure that there's going to be a death benefit that you can count on, because the policy has to have a death benefit to be considered a U.S. compliant life insurance policy, they go to the same reinsurance pool as all the other major carriers go to. So There's very little difference between buying a mass mutual policy and buying a policy from one of these offshore carriers in terms of the structure of the policy, but you do have the ability to get these significant tax benefits. And you can see here in this slide, I've illustrated how one of these structures is set up. We set up a trust. The foreign insurance carriers will not sell a policy to a U.S. person because these carriers are not registered to sell them in the States. So you set up a foreign trust. You fund the foreign trust with the premium or the assets in kind that you want to transfer to the policy. Then the policy is applied for, and we generally want to use the youngest, healthiest person in your family so we can keep the mortality costs as low as possible. Remember, we're looking for the tax leverage, not the death benefit. And the policy is purchased. The funds go into the policy. The policy funds are segregated into a segregated account. So if the insurance company goes under, that account is separated for liability purposes. That they're not subject to the general creditors of the insurance company. And then from that partnership, as you can see, or LLC, then they're segregated into, or they're allocated amongst various asset classes, much like you would treat your own portfolio. Now, folks, there's a couple of rules of the road that you have to understand if you want to have this treatment. This isn't for everybody. The most important rule, and where a lot of people get tripped up, is you cannot self-direct the accounts. If you're a day trader, if you're your own investor, you will not let some third party manage your money. This is not for you. You should just forget about it. Don't try to create some system with somebody you know that they're managing the account, but you're really pulling the strings. Because if the IRS finds out about it, they will disallow the transaction. But if you can get along with somebody else managing your money because you're going to save between 15 and 40% in growth because you're not paying tax on the annual returns, then it's worth looking at. You have to have a diversified portfolio, but most of us do that anyway. And there must be an insurance dedicated sub-fund, which is what that SA LLC accomplishes for you in my design in the previous slide. And for those of you that are technical people, that's the legal authority that allows you to do this. But I wanted you to know it exists because for those of you that have a portfolio where you're earning taxable income and you want to create a tax-free situation because it's your after-tax returns that are important, not your pre-tax returns, this is an option that you could look at. A quick question, and I'll move on to the next step. Okay. Now I want to talk about an estate planning technique. A question? Yeah.
Have you gotten into litigation amongst the he's no longer my friend category?
I'm not sure I understand the question.
I set this up and I get my good friend Jeff to be the investor. Now Jeff and I have a big fight and I can't stand Jeffrey anymore and I want to get it out of there. Have you faced that litigation?
The gentleman's asking, what if you pick an investment advisor, whether it's a friend or it's Mellon, New York, Bank of New York Mellon, which manages these structures, and you don't like the person anymore? Have I ever seen any litigation? No. If the individual who's managing the account or the company that's managing the account is not performing as they should, they're removed by the insurance company and a new account manager is placed. And I've never known of any litigation because we don't use friends to we want a professional money manager to run the policy. Let me now move into an estate planning question.
If you're insured as young, keep the premiums down, when do you actually cash in that policy? If they're young, when you take the money out of it, you take the money.
Remember I said the question is if the person's young, when do you cash in the policy? If you cash in the policy, you have to pay tax on whatever the untaxed gains is. So you leave the policy in existence, and when you want to take money out of the policy, remember I said you can borrow money out of the policy, no income tax. So most people will borrow the money out of the policy. Most people are investing for their children, their grandchildren, and they're just growing their assets on a tax-deferred basis, so you're going to accumulate your returns at a much higher pace, not paying tax on it. But if you should need it, then you can withdraw it from a policy loan.
Is that interest rate a wash? In other words, they're charging you 5 and you get 5?
Most insurance companies, when you borrow money from your policy, they'll give you a dividend equal to the amount of money that equal to the interest rate, so it becomes a wash loan. Yeah. Okay. I want to go into an estate planning strategy that I touched on yesterday, but it's one of the old tried and true structures. And if you have an estate that's growing, one of the goals is to be able to move your future growth out of your estate. I was asked the question earlier today, what do I think Congress is going to do with the estate tax? And I put this slide in here to remind me, just to indicate to you that I have no idea, but I think it's unlikely we're going to have much in the way of an elimination of the estate tax. I just don't see it coming. They've had their opportunities, and there's just too much political baggage for anybody who votes to do that. But the super freeze trust strategy, I've been talking at the MoneyShow since 1994 about, and it's still a very effective strategy. And I'll very quickly take you through how it works. The challenge for investors is to how do you shift the future growth of your assets. If you're worth $7 million now, and by the time you die, you might be worth $15 million because of the way that you're investing your estate. How do you take that $8 million of future appreciation and avoid paying estate tax on it? I mentioned in the opening ceremonies, families like the Kennedys and Onassis and the Waltons, they employ strategies. When Joe Kennedy dies with a $600 million estate and pays $137,000 in change in estate taxes, this doesn't happen by itself. They employ tax advisors to help them do their planning. One of the strategies that you can employ, that the average Joe out there can employ, is the super freeze strategy I'm going to talk about. Quickly, the case study that I talked about yesterday, that I think has is an interesting profile and how these results can be achieved and the benefits that you can achieve from them. Take somebody with an $8 million portfolio, growing at 7% a year. Over 30 years, that portfolio is going to grow to $60 million. When they die, there's going to be roughly a $30 million estate tax on an $8 million portfolio. The client wants to shift the future growth to future generations, generation skipping trusts, and he wants to be able to retain cash flow, which is what I find most people want to do when they're doing their estate planning. The first thing we do, we set up a family limited partnership, transfer the portfolio to the partnership. We have a general partner and we have a limited partner, as you can see here. When the portfolio goes into the partnership, no gain or loss recognized. It's a tax-neutral transaction, and now the portfolio is held in the partnership. The next thing we do is we set up what is technically referred to as an income tax effective grantor trust, or what I refer to as a super freeze trust. This is a trust which for income tax purposes is disregarded, and for estate tax purposes, the assets in the trust are not includable in your estate. And we fund that trust with a little bit of cash because the trust is going to be buying an asset from the taxpayer and issuing an IOU. And then the trust, of course, has the beneficiaries, which would be this generation and the grandkids, great-grandkids. And depending on how long you want to delay the distributions to the ultimate family members, you would select the jurisdiction that has the longest period of time within which to do that. Now, let me just talk to you about discounting, because this is one of the most exciting aspects of the law that most of us can, really take advantage of. We have to value the partnership interest because we're getting ready to sell it. Why? Because there's only two ways you can transfer assets out of your estate, ladies and gentlemen: either gift it or sell it. If you gift it, you have to pay gift tax on the value of the interest that you're gifting away. And most of you are not going to take out your checkbooks and write a check to pay a large gift tax. If you sell it, and if you sell it to a disregarded entity, you have no gain or loss recognized. So we want to sell the asset to the super freeze trust, the 90% partnership interest that we're trying to get the future growth out of our estate. And now we have to figure out what that partnership interest is worth. Now, remember, I said that the partnership has $8 million in assets, and we're going to be transferring a 90% interest. Now, how do you value it? Well, first thing that you can take into account the fact that you have the inability to market that partnership interest. So it creates a discount, it creates the ability to reduce the value. Then you're transferring less than a majority interest, so you get another discount. And based upon recent case law, you can now take into account in valuing the interest the unpaid taxes, the built-in gains in these assets that you'll be transferring to or selling to this trust, even though you have no plans or intentions on selling those assets anytime soon. With those discounts, with those reductions, you can take a significantly reduced value from 35, which is a conservative end of the scale, to as much as 50% or more to be more aggressive, depending upon. Real estate gets a higher discount than, say, marketable securities. So when we try to figure out what that partnership interest is worth, the valuation experts will tell us that with a $7.2 million asset, applying a 35% discount, the actual sales price is going to be not $7.2 million, it's going to be $4,680,000, and that delta, that difference between the 7.2 and the 4.68, that value disappears forever for estate tax purposes. That's never in your estate. So we have that price. We're going to sell the asset for $4,680,000. So we sell it to the Super Freeze Trust. The Super Freeze Trust pays us a down payment of $680,000 and issues an IOU to the taxpayer for $4 million. Now, this is a real IOU, folks. This has to be repaid. There must be interest that's paid annually on the note, and the government will tell us what that annual interest rate must be. They publish a schedule every month. You can even have prepayments on that note if you need additional cash. But it's a real note and it has to be repaid. Now, as you can see from this illustration, when the smoke all clears, we've got the children running the partnership, so the parents aren't involved in the control aspect, which the IRS looks at. You've got the 90% interest sitting in the super freeze trust, and all the future growth is outside the taxpayer's estate. And mom and dad are holding an IOU at $4 million. That IOU will never grow in value, and so it's always going to be $4 million until it's paid, no matter what the partnership interest is worth when mom and dad pass away. So let's look at the results here. We have a $7.2 million partnership interest, a 90% interest, which over 30 years will grow to about $58 million in my example. The estate tax would have been $27 million without the super freeze in place. It's $3 million with the structure in place, or an estate tax savings of $25 million. Now, folks, that's real money. I mean, that's with an $8 million portfolio, you can really do some significant estate tax planning by adopting this strategy. Now, I know I went through it very quickly because I don't have a lot of time, but if you have an interest, write this down, talk to your lawyers about it. It's called a sale to an intentionally defective grantor trust. He may not know it as a super freeze, but he probably knows it as an intentionally defective grantor trust. And go back and see your counsels. If they can't do it or don't understand it, then give us a call and we can help you put together. Quick question, and I got to move on.
What happens to the loan when you pass away? That loan still separate?
Well, the note's in your estate. If the loan isn't repaid before you die, then the value of that $4 million loan is in your estate. But the partnership interest may be worth $58 million by the time you die because of the appreciation, and that's not in your estate. You can't make it, you generally want to make the note no more than your mortality. 20 years is generally, beyond 20 years, and the IRS gets a little squirrely about that. Let me talk to you very quickly. Quick question? An intentionally defective grantor trust. I'll send you the slides, and all of this will be on there. So just take my slides to your attorney, and he should be able to figure out what I've done here. Quickly about premium finance insurance, because I think it's an important concept. In the last couple of years, there's been some new developments in the way that you can own life insurance. The problem has always been if you have an estate, life insurance is a great way to pay your estate taxes if you're healthy enough to get it. But the problem has been people don't mind buying life insurance, they just hate to pay for it. Well, one of my good friends back in Newport Beach invented a concept called premium finance life insurance. And he went to AIG and he said, will you loan money for life to my clients so I can sell them insurance policies? And this is why you should do it. The client is going to die and the insurance company is going to pay. So you have no risk and you're going to collect interest on that loan as long as the individual is alive. Now, when he took it to a few local banks, they said, well, we'll loan you for 3 years, we'll loan you for 5 years, but then you got to come back and reapply. He said, no, I want a loan for life. And AIG said they would try a pilot program. And today, this man has revolutionized the way life insurance is sold in this country. Because think about it. If you need life insurance and you don't have to pay back that loan until after your death, why would you not want to own life insurance? Yes, you have to pay interest, or if you have a strong enough financial statement, they'll accrue the interest. But if you don't have to pay the principal back and it gets paid out of the death benefit, why would you not buy the life insurance you need to pay your estate taxes? Because, folks, for a lot of you, all this fancy schmancy estate planning may be giving you a headache. Maybe the best plan for you is just to buy a nice big life insurance policy, put it into a trust so it's not in your estate, and when you die, the kids have the cash to pay the estate tax. And there's nothing wrong with a simple plan like that. You don't have to do all this complexity if you don't want to. But if you didn't want to pay the premiums and take the money out of your portfolio in the past, you now have a solution. There's another subcomponent of life insurance that I want to share with you. Maybe you've already been to some of Kevin Yerkes' workshops, but there's something called life settlements, and it's a very important industry which is growing probably as rapidly as any financial market is growing in this country, and you should know how it exists. Now, we use life settlements as a way of generating cash to be able to pay the life insurance that my clients want to have on their estates, because many of my clients buy large life insurance policies. But if you're a senior, and seniors are defined between 68 and 85, if you have life insurance and you don't need it anymore or don't want it anymore, or you have expiring term policies, do not let those term policies expire. Because Wall Street, and by Wall Street I'm talking about Deutsche Bank and Goldman Sachs and Berkshire Hathaway and companies like this they would love to buy your life insurance policies, and they'll pay you from 4% of the face amount to as much as 30% or more of the face amount to own your life insurance. Now you say, why would Wall Street want to own my life insurance? Well, think about it. If you're going to let your policies expire or you're going to surrender it back to the insurance company, you're going to get a paltry amount of money. Wall Street takes your life insurance. They'll pay you a pretty good sum for it. They'll continue to make the premium payments, and then when you die, they're going to get the death benefit, and they're going to receive double-digit internal rates of return. And if Wall Street can get double-digit rates of return from almost a sure thing, which is we're all going to die, and the insurance company is going to pay because they're only going to buy policies from quality insurance companies, their only risk is the time value of money. It's a tremendous investment for Wall Street. They're probably not paying you enough money for your policy. And what does Wall Street do with these policies? They use them to securitize bonds, and they repackage them and sell them to investors. So Wall Street wants your life insurance policy, and it's a growing field. Now, some of you who are 68 to 85, who have the capacity to buy more insurance and are healthy enough to get insurance, can buy insurance policies, hold them for a couple of years, and then resell them to Wall Street for a substantial profit. And let me give you an example of a client that we had done this for back in California. Got a client a year and a half ago, 75 years old, very good health, did a lot of estate planning with us, so he didn't need any more insurance to pay his taxes, but he had a lot of capacity. By capacity, that's the amount of insurance the insurance company will sell you based upon your health and your net worth. So this guy bought a $15 million whole life policy from Pacific Life. It cost him $900,000 for 2 years plus the interest. So he borrowed $900,000 from AIG, and they took a lien against the policy. In 2 years, he'll be 77. He's about 14 months into the program. He'll sell this policy to Wall Street for probably about 20%. There's no way to tell for sure. It's a bidding process, but 18 to 20% is a reasonable estimate. He'll get $3 million from Wall Street. He'll have to pay back his $900,000 loan to AIG, of course, but he puts $2 million in his pocket, and he's never written a check to buy the policy. He's financed it all. Question?
In order for this to work, a 75-year-old guy in good health?
You have to be in good health. I'm sorry?
He's in good health when he bought the policy.
Uh-huh.
When he sells the policy, does he have to be on his deathbed?
When he sells the policy, does he have to be in his deathbed? No. Now, the sicker you are, the more you'll get for it. But Wall Street, well, let me explain. The Wall Street buys a pool of policies on 77-year-olds. Based upon the law of large numbers, which is how the insurance industry is based, that's this natural law of large numbers, they know that out of 1,000 policies, a certain number of 77-year-olds are going to die. Some will die sooner, some will die longer. So they rely upon this universal law that is proven to be the one certainty. Now, if Sal died during that 2-year period, the insurance company would pay his family $15 million income tax free. If Sal got sick within the 2-year period, he might get quite a bit more for the policy because his mortality is reduced. Or he may decide to keep the policy and not sell it. Question in the back?
Based on what you said a couple minutes ago, why would this insurance company give that policy to him, issue that policy to him, if he has minimal need for life insurance?
It's not about having minimal need for life insurance. It's about what you can qualify for. People buy life insurance to create a secondary estate. If you've ever read any of Barry Kay's books, that's what he preaches, creating a secondary estate. People buy life insurance to leave money to their grandkids. Wealthy people buy life insurance all the time, and they don't need the money. Okay, I've got 5 minutes left, so I'm going to quickly go through my last strategy, and I'll be around to take questions. So in this particular case, we have used life settlements and are using life settlements. If we are financing a large life insurance policy and there's going to be a large interest cost to carry that loan, we'll buy 2 policies. One permanent policy, which will pay the estate taxes, and another policy which the taxpayer will hold for a couple, 3 years, and then sell that policy and use the proceeds on a life settlement to pay the interest carry on the loan on the permanent policy. So there's all sorts of ways that you can mix and match this concept. I just want to make sure that you guys know that it exists, because the startling thing about this conference is so many people have never heard of this before. And so now you have, and now you can use it in your own planning situation. The last strategy, and I'll get your question in a moment. The last strategy I want to talk about, it's not so much a strategy, but a problem. I run into so many of you who have lots and lots of money in your IRAs. 6 digits, 7 figures, 8-figure IRAs. And for some reason, you fall in love with your IRAs and you don't spend it. You don't take the money out. You use your other assets. IRAs are very tax inefficient assets to leave to your kids. Why? Because when you die, the government wants the income tax that they haven't collected from you in all those years, plus the estate tax on the value of what it's worth. So if you have an IRA with $2 million in it and you don't need the money, you're just letting it sit there and you're investing it, it's growing and growing. Why not take distributions out of your IRA? Some of you have to take distributions because of your age, but take a little bit more distribution. Buy a $2 million life insurance policy with that money. And then when you die, the kids are going to get the full $2 million instead of $500,000, which they would ordinarily get if you're up in the 75% bracket. A very simple technique like that can really maximize how you use your financial assets to be able to pass what should be passing to the kids. And yes, you'll pay a little bit more income tax on the distributions that you take out, but you're going to get so much more in the way of asset value by using that simple strategy. So there are many things that you can do with your IRAs to leverage up the value and make sure you pass what your kids should get. But if you just sit there idly and let those IRAs accumulate, I think you're going to run into some issues. You have a participation feedback form, and it's very important to our firm that you honestly fill those out and give me ideas, critiques, criticisms, and so forth, so that we know what sorts of things you want to hear in the future. I've got a couple of minutes. I'll take some, and then hand those to Michelle as you leave. And I've got a couple of minutes for questions. You have a question back there?
Yes, with regards to IRA, what if that's a Roth IRA?
What about it? I don't have the time to go through the difference between a Roth and a I'm just about out of time, but you can see me later and I'll be happy to answer your question. Sir?
In a family limited partnership, if you die, you set one up and your kids owe you $4 million, how much of that can you forgive?
How much of if in the $4 million note, how much of the $4 million note can you forgive? You can forgive the whole note, but you have to have a much higher interest rate. You have to. It's called a self-canceling installment note, but there's a premium in the interest rate. A lady had a question back there.
Yeah, how do you structure that insurance so that when you're getting that $2 million, you're keeping it out of your estate?
You put the insurance in an irrevocable life insurance trust. How do you structure the $2 million to keep the insurance out of your estate? You put it into an insurance trust, or you have the kids own it.
That's what you're selling.
When you're selling it, you just own it individually because you're going to sell it anyway, and you're going to take the proceeds.
Is a 401k, can you transfer that to an irrevocable trust without a tax?
Can you transfer a 401k to an irrevocable trust? No. Without a tax? No. The type of insurance you would buy for this life settlement strategy would be universal life, a non-term product. If you have term policies, ladies and gentlemen, do not let the policies lapse. You should convert the term or find a broker like Kevin Yerkes who can then turn around and find a buyer for your term policy. Instead of getting zero, in one of the case studies he talks about, his client got over $300 and something thousand just by not letting their term policy expire. Okay, I've got to go. I'll be outside. If I miss you, come down to my booth 801 and I'll be happy to answer your questions. Thank you all for participating, and I hope to see you at an upcoming Money Show. Thank you.